Okay, thank you so much everyone for joining us today. My name is Jay Huang. I am a senior associate at Scott Legal PC. Today we are going to spend some time and discuss the E-2 visa requirements and considerations for the renewal of an E-2 visa. So just a few things before we get started. Some of you may know that the firm was actually founded on an E-2 visa 10 years ago. The founder of Scott Legal applied for an E-2 visa to come to the United States to establish the firm. And the firm has successfully renewed its E-2 visa as well. So this gives us very deep familiarity and expertise with E-2 visas. Now, Scott Legal is a full-service immigration law firm, but we do particularly focus on E-2 visas. We have processed hundreds of E-2 visas, and we process many E-2 visas that are considered higher risk, which usually means with lower investment amounts. We have processed E-2 visas at consulates around the world, but our primary two consulates are Toronto and London. We will be continuing this webinar series. We are doing at least 2 webinars a month on different topics on immigration law. And at the end of this webinar, we will be sending out a few things to all participants. First, we will send you a copy of the PowerPoint that will be used in this webinar. Second, we will be sending you all a comprehensive guide to the E-2 visa that you can use as a resource. We will also be sending you a link that you can follow to sign up for additional webinars coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe to our YouTube channel and hit the notification button, of course, as we do regularly upload a variety of immigration law related videos. Finally, we will send you a link that you can follow to set up a consultation with one of our experienced attorneys should you wish to discuss your case further. As for today's panelists, we are lucky to have Kelly Wiener, who is a managing partner of the firm, who has leading expertise on processing a wide variety of E-2 visa cases in many different consulates. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. So without further delay, I will start the presentation. So let's first look a little bit at the basics of an E-2 visa, and let's overview the rules and regulations regarding the E-2 visa. So the E-2 visa is a non-immigrant visa for investors who are seeking to come to the United States to develop and direct a U.S. enterprise that they have invested in. Now, the E-2 visa won't necessarily lead to a green card, but it is possible for an E-2 visa holder to continue extending the visa indefinitely as long as the applicant continues to meet all E-2 requirements. And there are 2 options that an applicant can use when they seek to obtain an E-2 visa. The first option is the applicant can purchase an existing business in the United States. The second option is that the applicant can start up a new enterprise in the United States and make the investment towards setting up and establishing the enterprise. Now, it is important to note that there must be a treaty between the United States and the foreign country of which the applicant is a national. And with regards to treaty countries, you can definitely look up the list of the treaty countries by Googling Treaty Countries Department of State. But in essence, it includes many different countries from Europe, Africa, Asia, Latin America, and the Middle East. And the list does get updated from time to time. So it is good to, keep abreast of those changes. The validity period of the E-2 visa. Now, the length of the visa itself, it really depends on what is called the reciprocity schedule. And so that means it will depend on the treaty country national's country of nationality. And in many cases, it could be as long as 5 years, for example, for countries like Canada. or it could be as short as 3 months. It really depends on the reciprocity schedule. Now, it is important to note that the validity of the visa stamp is different from the period of your authorized stay. So what does that mean? A visa stamp is the visa that you can use kind of like a ticket to come to the United States and gain admission to, develop and direct your business. So let's say your visa is valid for 3 months. You will have a 3-month window during which you can come and gain admission to develop and direct your business. Now, the period of authorized stay is different. So every time an E-2 investor comes in, they will get 2 years of an authorized period of stay where they can be in E-2 status and develop and direct their business. So even if your visa itself is only valid for 3 months, you can come in and gain admission. Once you gain admission, you will typically be given 2 years of a time to develop and direct your business. So it is important to note the difference between the E-2 visa validity and the period of stay that you will be granted upon entry. So let's dig a little deeper into the E-2 visa requirements. So the first requirement is that the applicant must be a national of a treaty country. And also, there is an ownership requirement. It's also in the bottom here. The treaty country national must own 50% or more of the enterprise that is the basis of the E-2 visa. The person must make an investment. And what does investment mean? Investment means that the money has been put at risk. And what does that mean? It means that money was actually spent on, tangible things like, securing an office lease, paying professionals to, set up your business or, do marketing for your business, things like that. And if it's just money that is transferred to the business bank account and is just sitting in the bank account, unfortunately, that will not count as money placed at risk, right? Now, the amount of the investment of money put at risk must be substantial. And what does that mean? There is no hard and fast minimum in the law of a dollar figure where you need to meet to be substantial. But however, what it means, it is substantial in the sense that if you're starting up a business, of course, you have purchased and put money into everything that is necessary to really get the business up and running. So a variety of E-2 expenditures is recommended to meet this requirement, such as inventory, equipment, setting up the website, buying office supplies, paying the office or warehouse rent, spending on marketing, setting up the business entity. All of those business expenses are considered, what is necessary to get a business up and running in most cases. Now, let's talk a little bit about the source of funds. Another requirement is that you need to prove where the money came from, right? And the requirement is that the money came from a legitimate source. So that just means you will need to provide evidence of where the money that you spent on the business was sourced. So this can be any legitimate source, really. It can come from personal savings from employment. It can come from a gift from, a family member or a friend. The person will typically write a gift letter, and then we would also need to show where that person earned that money from. You can also source the money from the sale of a property that you own. So if you have a house and you have sold it and, receive capital as a result, you can, submit a copy of the purchase sale agreement to prove that you had owned the house and you have sold the house and you have received capital as a result. It could also be a loan. Now, there is a requirement for the loan, right? So the loan must either be unsecured, or if it is secured, it must be secured by your personal assets. It cannot be secured by either the E-2 business or by any of the assets of the E-2 business. So the security cannot be tied to the E-2 business. So that is the requirement for the loan. But if it's an unsecured loan, for example, like a personal line of credit, or if it's a loan secured to your, unrelated assets, such as your house, for example, that can also be considered a legitimate source of funds. Now, let's talk a little bit about the difference between starting a business and purchasing a business, in which case the escrow arrangement could be relevant to the situation where you're purchasing a business. So when you're starting up a business, you do need to spend and put money at risk by, purchasing tangible items, as I mentioned before. Now, if you're purchasing a business, there is an option you can use of when you want to put the purchase price, right? And if you don't feel comfortable, transferring the entire purchase price to the seller before you apply for the visa, because what if the visa gets denied, right? So one option you can use to protect yourself in those circumstances is that you can have an escrow arrangement with a third party where you can transfer the entire business purchase price to the escrow account, and the sole condition of the release of the escrow funds would be the approval of the E-2 visa. So as long as the E-2 visa approval is the sole condition of the release of the funds, the government will accept that, putting money in this kind of escrow is money placed at risk. So that is one option that you can take if you are purchasing a business. Now, the other requirement is that the business cannot be marginal. And marginality relates to the revenue generation potential of the business. So what this means is the E-2 business cannot just be a one-person shop. The profitability of the business cannot be marginal, which means it will generate more profits than just supporting the investor's livelihood, just supporting the livelihood of the investor and his or her family. Which also means the business will have potential to hire U.S. workers. So our recommendation is that if you're starting up a new business, the potential must be that you will be able to employ 3 to 4 full-time employees within the next 5 years of operations. Another requirement for the E-2 visa is that the business must be real and operating, or that it must be ready to start running once the visa is granted, or the business is already taking revenue, for example. This means everything that needs for the business to hit the ground running must already be in place. So, for example, the business space is already secured. The lease is already signed. All required licenses have been secured. If you need insurances, you have already purchased those insurances. If you have, client contracts for services in place, all of those elements will support that the business is real and operating and really ready to run as soon as the visa is issued. Now, another requirement is that the applicant who is applying as the investor must be coming to the United States solely to develop and direct the business. This would mean really the applicant should be playing a role in directing the business, not necessarily doing the on-the-ground work themselves. So really the vision is that the person who gets the E-2 visa will focus on managing the business and hiring employees to do the work, not necessarily just doing the work themselves. And the ownership issue, I have alluded to this earlier. The treaty country national must own at least 50% or more of the E-2 company. And finally, the final requirement is that the applicant must show that they have the intent to return to their home country upon the expiration of the E-2 visa. This can be usually satisfied by a signed statement of the applicant to that effect. Because, as I mentioned before, the E-2 visa is a non-immigrant visa. So the ordinary considerations of non-immigrant intent would apply here as well. All right, so let's move on to the next topic, which is how much investment is enough. So as noted before, the requirement is that the applicant must invest a substantial amount of money. Now, there is no hard and fast dollar value minimum in the regulations or law, right? However, it does need to be substantial. And what amount is substantial will depend on the type of business that is being started. So let's talk about some hypotheticals. So let's say you are, applying to start an office type consulting business or a service-based business. This would typically require a lower amount of startup capital. For example, let's think about, 80K, 100K. And there may be just a few upfront costs to start that kind of business, a service-oriented business. Let's say, you need a commercial lease. Let's say you need, computer equipment. Let's say you need furniture for the office, things like that. Let's contrast that with, if you're starting a restaurant, for example, or a manufacturing company or a retail store. Those types of businesses typically require higher upfront costs to start. So to meet substantiality, you would typically need to put in more capital than, compared to if you're starting a service-oriented business. And this is because those types of businesses typically require a higher amount of capital to start. Typically has more expensive equipment and machinery that you need to, procure. Maybe you need larger space to store, warehouse the inventory, etc. So for those types of businesses, you would likely want to put in a higher amount of capital to meet the substantiality requirement. Now, there is also what is called the proportionality test that the government uses, in which the government, kind of does an analysis of a inverted scale on, which means that the smaller the total cost needed to start up a business, the higher proportion of these costs the government would expect that you would already have been spent. For example, for a small consulting company that I mentioned before that will require 80K, 100K to set up or purchase, the government would expect that the applicant would already have spent 100% of what is needed to start that kind of business. By contrast, if the business is for a 10 million valuation manufacturing company, for example, and the applicant spent about like 1 million towards setting up that kind of business, that would likely meet the proportionality requirement, the substantiality requirement, even though it's only 10% of the total valuation of the business that is expected. Now, let's talk a little about the scenario of when you're buying a business. So to meet the substantiality requirement, what you would do is you would compare the cost of buying that business to the fair market value of the business, right? So for example, if you bought the business in the open market, you likely did pay the fair market value, and that will likely enough, to be considered a substantial investment. Another thing to think about is that where you apply matters. So different consulates around the world have different standards on what they see as a substantial investment, right? So there are some consulates in the world that will consider any investment below $100,000 as insufficient, right? While other consulates are open to investments lower than that. In terms of, objective dollar value. So it is very important to work with a law firm that understands these nuances when you're, preparing your E-2 visa case. Another couple of other notes is that franchises can be a good option for E-2 visas. If you any payment that you make towards the franchise fee or things like that, you can include in your investment amount. And also what franchises typically do is they bring you training materials, marketing help, and other sorts of assistance that would really help convince the consulate that your business is ready to go and that you will be able to develop and direct the business in a successful way to meet the marginality requirement. There are common good and bad E-2 visa expenditures, and we will go into a little bit more detail in the next slides. That just means that some expenditures are better to count as E-2 visa investment than others. So there are certain types of business expenditures that we would recommend using or not using, and we will look a little bit closer in the next slides. The other topic to cover here is, do I have to hire U.S. employees, right? So we would strongly recommend that the business, when you're setting up a business and when you're applying for the E-2 visa, that the business plan projects that the E-2 enterprise will be able to hire at least 3 to 4 full-time employees by year 5 of operations. You don't need to necessarily have those employees by the time you apply for the initial visa, right? Because you're projecting that you will work on developing and directing your business. However, the business plan should project that the business will grow sufficiently to be able to support 3 to 4 full-time employees. And as I mentioned before, the standard for that is that the E-2 businesses' revenue generation and profit generation potential must be more than enough to just provide a minimal living for the investor and his or her family, right? So it cannot look more like a self-employment situation. It must be that the business would be large enough to support several employees by year 5. W-2 employees versus 1099 workers. So W-2 employees are what is called full-time, regular employees, and 1099 workers are when you hire contractors. Now, our general recommendation is that W-2 full-time employees are favorable as compared to 1099 workers. Now, there may be some instances where your particular industry, it is the custom to, use 1099 workers as opposed to W-2 employees. And if that is the case, definitely you can show marginality. You can meet the marginality requirement through showing that you have enough 1099 workers, that your business is generating enough revenues to support, generation of jobs through 1099 arrangements. So for example, if you're in the construction industry and you hire a high number of workers on contractor arrangement, or if, for example, if you're in the beverage industry and beverage or food industry, and if you hire, if it is the industry custom to hire 1099 workers, definitely you can meet the requirements through that. How can I prove marginality? So when you're initially applying for the E-2 visa, a strong business plan is highly recommended. In the business plan, you would include hiring projections for the next 5 years. And those hiring projections would be supported by financial plans for, profit and loss tables that you project for the next 5 years that would generate enough revenues to support that. And you would also explain the basis of calculating those revenue projections, right? So you would be able to explain what are the assumptions that you used. If it is an existing business, or if you're, applying for a renewal, the way to prove that you have hired workers is that you would bring form W-2s. If you hired full-time employees, you would bring recent pay stubs. You would also bring tax returns for the corporation, for the company, that shows the revenues that you have been earning in the past several years. If you hired 1099 workers, you would also bring copies of those tax forms, and those historical hiring records would be evidence that you meet the marginality requirement for your business. All right, so let's talk a little bit about considerations regarding the business plan. So do I need a business plan? Now, the answer is yes. So if you are starting a new business for your E-2 visa, definitely it is our strong requirement to include a business plan. And the reason why is because you would want to really show the consular officer the profit generation potential and the hiring potential of your business once you set it up towards meeting the marginality requirement, as I mentioned in the previous slide. Now, let's compare this with purchasing an existing business. Now, if you have enough data regarding the performance of the existing business that you purchased, regarding hiring potential and the revenue generation potential, maybe you don't need a business plan. So this is definitely a fact-specific inquiry that you want to talk to your lawyer about. But however, let's say the existing business that you purchased is not doing very well, or if there is not enough information regarding, the hiring history or the revenue generation history of that particular business. In that case, we would strongly recommend that you prepare a business plan when you're applying for the E-2 visa to really show the data behind your projections of how you will, grow the business, or how you will manage the business to generate this, the job creation and the revenue generation potential to meet the marginality requirement. And what should the business plan contain? So here are some recommendations on the content that we can add. So the business plan should typically contain an executive summary that really gives the consular officer a good idea of who you are, what you plan to do with your business, and who do you sell to, which means what is, your client base, what will be the demand, what will be the, pool of, clients that you will be targeting for your business. You would also contain market analysis and research regarding the field that you are operating in, right? Really to analyze the opportunity that exists for growth in that particular business area. It is also important to include a marketing plan to show how you will be able to market your services, market your products to the United States market, to support marginality and to support the assumptions in your revenue projections. A personnel plan, as I mentioned before, it is very important to include a personnel plan that lays out who you will be hiring, for what kind of positions, what salary will they receive, and how will you support, those employees. And we recommend, including at least 5 years of hiring projections, and including the job description, salary, and the exact timing on which you will add, each additional employee in the plan, so that you can present a very detailed roadmap of, who you will hire and when. Similar to this, it is important to include a comprehensive financial plan for the business. And this should include 5 years of financial projections, would include the revenue projections and the assumptions behind those revenue calculations, cash flow projections, how will you generate enough cash to support the operating costs, and also include a balance sheet, a projected balance sheet for the business that will show the assets and liabilities and how that'll all balance. Do I need to hire a professional to prepare this business plan? And that would really depend on, the level of your, needs. Now, even if you hire a professional, though, all of the information must be coming from you, and the professional can give you suggestions on, the numbers to use and the financial calculations. However, at the end of the day, the applicant himself or herself will need to be completely familiar with all of the numbers that you present in the business plan and be able to explain about them in person at the interview for the E-2 visa. That will be a very important element to consider. All right, so I will then now turn it over to Kelly, who will take us through some other topics regarding the E-2 visa and considerations for renewals.
Thank you, GA. Perfect. So let's talk about, some of the, current things that we're seeing. One is, should you spend your money in the United States for your E-2 investment? So there is nothing in the regulations that requires that you spend money in the United States. That being said, the investor visa is meant to facilitate trade and economic benefit between the treaty country and the United States. And our experience is that officers do like to see purchases made in the United States. So even though it's not required, it's definitely favorable for the case. So for example, if you're importing something or you have like a bunch of inventory and that expenditure is not in the US, that's okay. That can definitely still be included, but you would also want to try to make some expenditures in the US. So if you're purchasing equipment or furniture or computers or anything like that, all of that ideally, would be purchased in the United States. Something else to be aware of in the E-2 process is the possibility of something called administrative processing. So when you go to your visa interview at the consulate, you can, be approved, you can be denied. And another thing that can happen is they can put your case into what they call administrative processing. So usually if they do this, they'll issue you a form called a 221G. It is a technical refusal. And so if you receive this form, there's a few things it could mean. One is it could be almost similar to a request for evidence. So you get those usually from USCIS in the United States, but consulates sometimes will want some more evidence. And so they may issue a 221G and they'll write on the form what it is that they want you to send. So in that case, usually administrative processing can be resolved relatively quickly. You would send in the information they ask for, and then they can make a decision on the case. Another thing that can happen with administrative processing is that there's some security concern that possibly has come up with another agency, that's not just the Department of State or not the consulate. And if that happens, sometimes they won't ask for any more information, or sometimes they may ask for very detailed information on kind of address history, employment history, travel history. And if they do that, sometimes this does mean that there is a security concern they have. In that case, administrative processing can sometimes last, several months, even up to and over a year sometimes. And unfortunately, in those instances, the consulate really doesn't have control over the visa adjudication timeline. They are stuck waiting for whichever agency has flagged the application to send them the all clear to go ahead. So if you are in a situation with administrative processing, it's good to try to understand, which reason your case is an administrative processing for. If it is a security reason, often they will not provide more context other than to say this is administrative processing and we don't guarantee a timeline. And then you would just continue to follow up, every month or every 30 days or so to try to move the case along. But ultimately, in that scenario, the consulate is constrained in what they are able to do to move the case along. They would be waiting on that other government agency to clear the case. So another thing that can that's kind of come up in recent years is ever since the pandemic, where consulates were shut down and timelines changed, more people have been doing USCIS filings. So if you do a USCIS filing, so if you're in the United States in a valid status that permits you to change status, then you potentially have the option to change to E-2 status instead of going to a consulate to get an E-2 visa stamp. So a few important things to note. If you are doing a change of status, first, again, make sure you're in a status that allows you to change status. So ESTA does not. If you're here on ESTA, you're not permitted to change to E-2 status. But let's say you're here, maybe you came in as a B-1 business visitor to maybe check out some office space. And for one reason or another, you now decide you want to change your status to E-2 instead of going to the consulate. So this is possible. There are some benefits, so one is that you don't have to leave the United States. Another is that there's not an in-person interview. It'll all be decided on the papers. Another benefit is that USCIS is often much friendlier to lower investment amounts than consulates are. So for most consulates where you want to be, in the at the lowest range, you want to be in the 60, 70, $80,000 for the investment. With USCIS, they can be much more permissive, particularly for service-based companies where it's very, reasonable that they could get started with very little, very little investment. Those investments sometimes can be as low as $30,000 or $40,000. Ideally, most of that would be spent. There could be some working capital, but that can be a big benefit of USCIS filings. There are some downsides, though. So one is that USCIS filings, they are much stricter on the source and trail of funds. So they do pay, with a consulate, for example, if you earned money from employment and you transfer that money to the US, you may be able to just provide your tax returns, and then proof of the lump sum transfer, and then proof of the expenditures. With USCIS, though, they would want to see a dollar for dollar accounting of that money. So they'd want to see your tax returns. They'd want to see your payroll, hitting your bank account and then being maintained there. So if it was transferred out or transferred somewhere else, that you would have to trace all of those funds, through up until you make the expenditures. So they are much, much stricter on that. They're also much stricter on certain issues such as licensing. So if you have the type of business that would require you to have a license to run the business, they're very sensitive to those issues. And they do want to see that the applicant is really focusing on high level tasks in developing and directing the business. So that means they often want to see that employees are going to be hired on the earlier side to make sure that the E-2 applicant is not engaging in skilled labor, but is actually focused on just developing and directing the business in a high level way. So let's talk a little bit about, the ongoing COVID issues. Thankfully, this is becoming less of a concern over time, however, still worth talking about. So, when the pandemic first hit, consulates shut down. And ever since then, as they started to reopen, they've really reopened on a very ad hoc basis. So this means that the Department of State has given the consulates a lot of freedom in terms of prioritizing cases, how to reopen. Certainly country conditions in the various countries will impact, the ability to reopen, the ability to have local staff, or even embassy staff. All of that is very relevant into how the consulates were able to reopen. And for some of them, it's taken a lot longer than others. So you have certain consulates like Toronto, for example, where processing times are essentially the same now that they were pre-pandemic. Japan is another one that recovered quite quickly. But then you have other consulates, for example, Bogota in Colombia, where, up until very recently, they were not even accepting any new E-2 applications. And they're now still working through a backlog of applications that were submitted, during the pandemic and after. It is important to discuss with your attorney, and to figure out, what are your options for where to apply, because the timelines do vary significantly. Whereas at a very fast consulate like Toronto, they may review it in a couple of weeks, and maybe you can get an appointment within a month or two, or even less sometimes. Whereas then there's other places where it may take a year, or it may take more than a year. So all of those things are very relevant to, to discuss with your attorney, and, appointment and processing times are really a moving target. So that is something to take into account when you're doing an E-2 application. You can move to the next slide. All right, so let's talk about a few kind of complex areas that come up for E-2 visas. So one is the source and trail of funds. So I mentioned this a little bit earlier. Particularly for USCIS filings, depending on, where the money came from, it may be viable to do a filing with USCIS or not. Even if you got the money from a transaction that happened 20 years ago, they will want to see those documents. They will ask to see that, appropriate taxes were paid on the documents, and that the money was maintained in a particular place, and that there's a clear trail of funds from wherever you received the money up until you spent the money on E-2 expenses. So if it is a situation where you have a very complex source and trail of funds, or you really can't trace the money, or, you got a big lump sum of cash and you put it under your bed and you left it there for a long time, that's going to be very difficult to file with USCIS. So you do want to talk, to your attorney to figure out, is a USCIS filing viable given my particular source of funds? And if it's a situation where you haven't transferred your money yet, don't transfer your money until you talk to an attorney to make sure that it's all going to be, traceable in the way that the government wants. A couple things about source and trail of funds that also come up a lot. So one is that for the source of funds, a loan may be acceptable, but a loan cannot be secured by the assets of the E-2 company. It has to be secured by personal assets. So, or it can be unsecured, but it just cannot be secured by the assets of the E-2 company. So if you have, for example, a private residence, or a home that you own, or a property, or a car, and you take, a line of credit, that's an acceptable source of funds, but you cannot take out, a loan and have the E-2 company be the security for that loan. Additionally, gifts are acceptable. You can get a gift from a family member, from a friend, but that person has to be willing to show where they got the money. So you can't kind of provide a gift letter and say, yes, it's from, they sold the property, and just provide the gift letter. You would also have to provide the purchase sale agreement for the property, proof of them receiving the money from the sale, and then proof of them transferring the money to you. So, sometimes people think, well, I can get a gift and then I can avoid providing this other documentation, but that's not the case. So other things that come up a lot, small investment amount. As GA mentioned, we do process, smaller investment amounts very frequently. And she's talked earlier in this presentation about how much investment is enough. When you do have a small investment amount, you really need to think about, how can I strengthen other parts of my application? How can I show that this is a viable business model? Do I have letters of intent from clients or signed contracts showing I'm going to have cash flow, that there's an interest in my services? Do I have a strong business plan? Have I been able to hire employees? Is there market research or publications or other documentation I can provide that really supports that I've spent everything necessary to get the business up and running? So all of those things are much more important when you have a small investment amount. Something else that comes up, people ask, can I get an E-2 visa? If I have two investors, can I get two investors for one business? And you can, yes, that's possible, but you each need to own 50% of the business in that scenario, and each person needs to make an investment. Ideally, the investments would also be around a similar amount, right? You wouldn't want to have one investor, who owns 50% investing $5,000 and the other one invests $120,000. In that scenario, the person investing $5,000, will likely be found to have not invested a substantial amount. If you do have a situation like that and both parties are of the same nationality, you could consider doing an E-2 investor and E-2 employee application instead of two investors. Something else that comes up a lot are substantive changes to the business after filing. There are some people that get the E-2 visa and they, may not be aware. They think, okay, I have a visa and now I can start up any business I want in the United States, or I can change my business. And that's not the case. When you get the E-2 visa, you're getting an approval for a particular company. Often that company name is even annotated on the visa. And what you're being permitted to do is run the business that you represented to the consulate. That doesn't mean that the business can't change. For example, if we had a marketing consultancy and they were going to focus on finance clients, and over the years they found that they actually had a stronger niche in technology clients. That's fine. They're still providing the same service as a marketing consultancy. But let's say you open up a marketing consultancy and now you close that down and you open up a restaurant. That does not work because that is a substantial change. So if you want to do that, you want that have that change in your business, you first have to go back to the consulate or to USCIS and indicate I'm making a substantial change. Here's the proof of my additional investment. Here's the proof how this meets the E-2 requirements. And you have to get that approval before you start working at the new business. So if you're in a situation where you got the approval for a certain type of business, and you want to make a very substantial change to the type of service you're offering, that's something where you would want to go back to your attorney, discuss first, and then submit to the consulate or to USCIS if necessary to get that approval before you go ahead with any changes. Because if you go ahead with changes and they ultimately, like, you shut down your marketing consultancy and now you're running your restaurant, now when you go back to the consulate, they could say, well, you've been out of status this whole time. You weren't, abiding by the terms of your visa. All right. One last one to talk about: family business purchases. So this is possible. We've processed many E-2 visas where people are purchasing businesses with a family member or from a family member. That being said, they are scrutinized much more heavily, particularly if you're purchasing a business from a family member. In that circumstance, it's generally recommended that you get some type of objective valuation, and the financials that are there for the company. The purchase price should make sense in light of those financials and in light of the valuation of the company. So if, the company is looking extremely valuable, looks like maybe it's worth, $1 million, and your brother is willing to sell you 50% for $50,000, they're going to look on that with suspicion. They're going to wonder, is this really the fair market value of the company? And if it's not, then the investment may not be considered substantial. So if you are doing a family business purchase, just keep that in mind, that you can expect more scrutiny, more questions, and make sure you have that objective valuation, or that the financials support that the amount that you invested was reasonable, in light of what the company is probably worth. All right, let's run through some common reasons for E-2 denials. So one is a low investment amount. There are some consulates that are friendlier to low investment amounts. USCIS can be friendly to low investment amounts, and there are some consulates that really are not. Particularly consulates that tend to process mostly large company registrations, maybe used to seeing millions of dollars as standard E-2 investment amounts, and they may not be as friendly to kind of small and medium businesses or individual entrepreneurs who are investing, $40,000, $50,000 to get an E-2 visa. So it is important to discuss with your attorney, strategize, think about where can you apply, and make sure that the investment amount, is reasonable in light of what's happening at the consulate at that time. Another reason could be the nature of the business. So there's certain businesses that just inherently receive more scrutiny. For example, real estate businesses. Many consulates even have on their FAQs, it is not possible to just purchase a residence in the U.S. and use that as an E-2 business. Owning property, passively owning property, or even passively owning property and renting it out, this is not considered to be, real and operating enough to qualify for an E-2 business. Consulting businesses are also heavily scrutinized, partly because the consulate can be concerned that you're going to come in and not hire anyone, just operate as a solo consultant. So if you do have one of those types of industries that's more heavily scrutinized, you do want to work with your attorney ahead of time to address some of those concerns. So for a real estate business, you want to make sure it's very clear in the business plan that it's an active enterprise, that it'll be hiring people. It's not just going to be purchasing one or two properties and renting them out without any activity. Another reason for denial could be location. So as I mentioned earlier, some venues are more or less receptive to lower investment amounts. And in addition, there are some venues that are more or less receptive to E-2s generally. So there are some consulates that are processing, hundreds and hundreds of E-2s, each month. And there are some that maybe have processed two. So it is important where you file because the knowledge that the officers have and the way that they interpret the regulations definitely can be different across, different consulates. So another reason for denial, concern over whether the business is going to create jobs for U.S. workers. So this is the marginality requirement. The business needs to support more than just the investor and their family. As I mentioned, this can be, this concern can be exacerbated if you have a type of business like a consulting business where they're worried you're going to be a solo consultant, or if you're someone who's run a similar company in your home country or somewhere else for many years and you never hired anyone. This is another reason that they could, look at your business plan and feel less confident that you actually will meet the marginality requirement. So if this is a concern for your case, sometimes it can be very helpful to hire an employee before you file. It's not required, but in those types of cases, it really can be, something that strengthens the application significantly. Another reason could be issues with the adjudicating officer. So consular officers are human beings. Sometimes, they have bad days. Additionally, sometimes there are officers that just take a very strict, view of the regulations. I attended a session with some former consular officers recently, and one of them was talking about how, the person they worked next to had a 25% approval rate, and another person they knew had a 70% approval rate. So that just goes to show that although the law and the regulations are the same, the way that they're interpreted are different. And with this type of visa process, when you go to the consulate, the officer does have full discretion to grant or deny the visa. So that can happen. Ultimately, if you do feel like you got an officer that really was unfair, didn't hear you, there is usually an ability to reapply, and most consulates will try to give you a different officer when you reapply. They don't guarantee it, but most that we know do try to do that. So another reason for denial may just be that it didn't meet the requirements at the time of filing. A file that just didn't include what was needed. Or if, let's say you have a scenario where you are the treaty country national and you have a minority share in the company, maybe you own 30% and you have a US citizen, relative or something that owns 70%, that just does not meet the requirements. And so in those cases, the case will be denied. We had another case where somebody, they spent $2,000 and put $98,000 in a business bank account. $2,000, even with USCIS or a consulate that would accept a low investment amount, it's just not going to be considered substantial enough. So we advise this person on what else they could spend money on, and gave them some ideas. They spent closer to $50,000, went back and were approved. So there can be things you can do to try to rectify some of these issues, even if you did receive a denial. All right, what does it take to renew an E-2 visa? So hiring U.S. workers is key. We generally recommend at least 3 full-time equivalents within 5 years. The salary doesn't matter in the sense that it's okay if they are, lower paid employees. That being said, you should be, following minimum wage laws in the state where you live. And certainly having higher paid employees may look more favorable. As Jay mentioned earlier, if you do have an industry where it's very common to just hire 1099, independent contractors, you can try to argue that the company meets the marginality requirement based on that. But in that circumstance, you would want to show a very significant amount paid to these 1099 contractors. So for example, we have clients that have not hired workers, or maybe they hired workers, but then because of the nature of their industry, they ended up just working with independent contractors, and maybe they're paying $400,000, $500,000 a year to these workers. In that case, where the amount being paid to the 1099 contractors is so high, generally you're still able to argue that the company is making, a significant economic contribution. But if you have, a couple 1099s that you paid, $2,000 to, and you have one part-time employee, that's going to be a very weak case for renewal. You do really need to make an effort to hire workers in the US. And even though in these outlier circumstances, 1099s may work, much, much stronger to hire W-2 employees. The other thing that they'll look at is really financial data. So, many consulates will want to see tax returns for the last 2 years. Some consulates will ask for all tax returns, since you last, got your E-2 visa. If you met the revenue targets that you had projected, that's great. You can certainly mention that in your, E-2 renewal cover letter. They'll want to know, is the company profitable? If it's not, does it have a plan to become profitable? How is it supporting itself? Were additional investments made? In an ideal scenario, you're able to show, consistent or growing revenues and enough, cash flow and profit to support, the investor, and then also to support employees. So they will want to see that payroll information. They'll want to see W-2s and 1099s. You'd want to provide information about the history of the company, like how do the marketing and sales plans work? Are you increasing business volume? Depending on the type of business you have, are there testimonials out there, reviews, about your business? Those can be helpful as well. If the company is not doing well, can you provide, a kind of an updated business plan that shows that you will be hiring employees and a realistic plan to do that? And then also just, does the company still meet the E-2 requirements? So they'll want to see updated proof of ownership. Often this is going to be reflected on the tax returns. And if there's been any changes to the business, you want to make sure that those changes aren't so substantial, like we talked about previously. So if you're trying to renew, you were running a marketing consultancy, now you have a restaurant, you have a very serious problem. Unless that was contemplated in your business plan initially. So if there have been minor changes to the type of business, like you're a wedding photographer, and now you've added a wedding products blog, things like that are kind of a natural outgrowth of the business you were doing, those can kind of be added to the, to the renewal application and the explanation. But if you have a major change, that's something that could be problematic, where maybe you need to submit, not a renewal application, but maybe a brand new application with a new investment amount. All right, so we've reached the end of the presentation. I think we can look at a couple questions that have come in. So someone's asked about EB3 and the process of switching from a TN to EB3. So we do have webinars that are focused on, the process of temporary visas to green card. So I'd encourage you to check those out, as well as the free resources that we have, on our website. Because this presentation is not focused on that, so we'll there's other presentations where this would be a relevant question. Someone's asked, when we set up a business in the US and it started to run and generate earnings, can we travel or stay in the US with a visa other than an E-2? If it is an online business, doesn't make any difference. So when you come to the United States, let's say you want to come as a B1 business visitor for a couple meetings and you're going to leave in a week, that may be okay. What's not okay is to come into the United States on a B1 or B2 or a non-work visa, and to stay in the United States and work at the business. So if you're coming again for, like, you have a business in the US and maybe you're coming for a week to visit Disney World, and maybe you take a couple phone calls while you're here, that's fine. But if you're coming, as a, on a B2 and you're staying for 6 months, and while you're here, you're running the business, that's not okay. So you would need a work visa. So in that case, so when you're entering the US, they do look at frequency and duration of your visits, and they will ask what you're doing when you come in. So if you're coming in, each week or each month, for several days or a week at a time, and they know you have a business in the United States, they ask you questions, that's generally not going to work, on the B1, B2. You would need a work visa if you're coming into the US frequently and staying frequently and doing work while you're here for the E-2 business. So GA, do you want to take the second one about the change of status?
Mm-hmm. Sure. So if you apply for the change of status to E-2 and you're approved, the approval will be for 2 years. So but it is important to note that if you change status, right, the change status to E2 is only valid for that particular stay. So if you need to leave the United States within that time, then when you come back in, you will need a visa to come back in on the E2. But generally, yes, if you apply for a change of status, that will be granted for 2 years. Is it okay to apply to change of status from B1, B2 to E2, or is it not recommended? So, right. So the timing of, when you apply for a change of status does matter, because there is the intent issue, right? So definitely talk to an attorney to really talk about the particular circumstances in which you're changing status from B1, B2 to E2. However, as a general matter, yes, it is possible to change from B1, B2 status to an E2 status. That is possible to do. And Kelly, do you want to take the next one?
Sure. So what happens if you have to expand the business or change your location? That's fine. Again, though, the business expansion should be in line with what was contemplated in your business plan. So for example, let's say that you are an IT services company and then you also want to do app development. That should be contemplated in your business plan. Ideally, expansions to the business, you want to include them so that you have an arguable reason why you were able to expand the business in that direction. Changing the location of your business, that's also fine. What you don't want to do is you don't want to dissolve your E2 entity. So if you do need to transfer to a different state, you want to be transferring the same entity. You don't want to be dissolving the entity that your E2 was granted for. And then there are some consulates, for example, Toronto comes to mind, where they do ask, like if the headquarters change, they ask you to inform them. Most consulates, it's really not a material change. If you were doing business in Texas and now you're doing business in Florida, as long as you're doing the same work, it's really not considered a material change, again, as long as you haven't dissolved your company. But it is something to, like it is something where for certain consulates, they may want to hear, yes, you've changed your location. Someone's asked about the recording. So the session is recorded and it will be made available. So you will be able to watch the recording. So GA, do you want to take this one?
Sure. Is the seller generally okay if the buyer is applying for an E2 visa, which has escrow fund conditions? So when you're purchasing a business, definitely talk to the seller about your circumstances, because some sellers may be okay with that, some sellers may be not. In our experience, we have seen plenty of cases where the seller was okay with putting the funds on escrow with the condition that the funds are released when the person is approved for the E2 visa. So that is quite common, actually. So definitely, though, this would depend on the seller. So when you're negotiating to buy a business, definitely make that negotiation upfront, so that you know what the options are that you can use. If you travel after being granted a USCIS change of status, is it easier to acquire the E2 at a consulate? So that really depends on the fact of the matter, right? And it is important to know that when you're applying for the E2 visa at a consulate, it is considered as a new application. Although you did get the approval from the USCIS, that is not controlling. The consulate will have their own, assessment of the case, and they will, basically treat it as a new application. So, yeah, whether it is easier or not, we can't really say in general terms. But what we can say is that it will be a new application.
Additionally, one thing I just want to add there is that, like, let's say that you get the E2 change of status and then you run the company for just a few months and then you go to the consulate and the company hasn't been doing very well because you've only been running it for a few months. That's a scenario where it really wouldn't be as favorable. Now they might look at it and say, well, like, you haven't really, had much success with the company. And we're not just basing it on the business plan. Now we're basing it on the actual performance. So it is a very nuanced question. And I think the important takeaway is that the consulates do not at all rely on the USCIS approvals. In fact, they often feel that each USCIS and the consulate often feel that the other does not adjudicate correctly. So it is often, it's not that it is a negative factor, but it does not in any way mean that your, E2 consular application will be approved just because you were approved with USCIS. Someone's asking about applying for a self-employed H-1B. So, again, not relevant to this webinar. We do have many, resources on our website that do talk about what the options are for people who own companies and want to, potentially apply for an H-1B. So someone's asking about E-2 requires minimum 50% ownership. If your business partner shares your nationality, but is also a US citizen, then their nationality does not count for purposes of the E-2. So in that circumstance, you would have to own at least 50%. And the US citizen who's a dual national, you could not use their passport to qualify for the E-2.
All right, so it seems like that is all of the questions that came in. Thank you everyone so much for your participation. Thank you, Kelly, for sharing your expertise. And yeah, see you everyone later and have a great day.
Thank you.